So this is our last snippet for the Obama years, and here the focus is on social issues and the Obama term. And the two key areas are sexual orientation and race. The key time period is really Obama's second term. There wasn't much that went on in the first. With regards to sexual orientation, the turning point decision comes in 2013. It's a case filed by this woman, Edie Windsor, who's a New York resident whose wife had passed away a few years earlier. When her wife dies, she gets an estate tax bill, which she would not have had to pay if her wife had been a husband, because the federal government doesn't recognize her marriage. Remember that law that we looked at a couple of weeks ago, this DOMA Law Defense of Marriage Act, which is the federal government is not going to recognize same-sex marriages performed in the states. Oops, why did that happen? So the result of the Windsor files a lawsuit which goes into which goes into federal court. Eventually, the Second Circuit Court of Appeals eventually works its way up to the Supreme Court. And in a 5-4 decision with Justice Kennedy, no big surprise here, writing the opinion, DOMA is struck down, and it's a very, very broadly worded opinion, where he argues that the principal purpose of this law is to impose inequality, not for other reasons like government inefficiency. And he singles out, even though Windsor and her wife did not have children, he singles out the effect of this law on the children of same-sex couples. And the general sense here is that Kennedy is kind of teeing up challenges to state marriage bans down the road. So the only issue in Windsor was, can the federal government refuse to recognize same-sex marriage? And the Supreme Court here says no. The two principal dissents to Windsor take very different approaches. Chief Justice Roberts says that all Kennedy did was to decide this federal case. It has nothing at all to do with same-sex marriage. Justice Scalia, though we've encountered him in gay rights cases before, it's a very passionate dissent, and he argues that the majority has basically said that opponents of same-sex marriage are motivated by animus, and it's very unlikely that the court will take a different view with regards to state challenges. And the Scalia dissent also goes through the Kennedy opinion and basically says, look, if you just change a word or two in this opinion, it would apply to state bans to same-sex marriage as well. So the question moving forward into Obergefell, which we read for today's class, I'm not going to summarize here, is the Roberts interpretation of Windsor, or the Scalia interpretation of Windsor, the correct one. At the time of the Windsor decision, same-sex marriage is legal in all of the states that are in green. Some of these cases had been as a result of court action, but in a handful of cases, Washington, Minnesota, Maryland, and Maine, it had been a result of popular referenda. So the public opinion is changing on this issue. But all of the states that are in kind of gold on this map, these are states that had constitutional bans on same-sex marriage. So the only way to get rid of them was through federal court action. So after Windsor, gay and lesbian couples file challenges to these state bans in every single state in the country that didn't permit same-sex marriage. And the first of these challenges comes up in, of all places, Utah, where the decision comes down. Utah is a very, very conservative state. The Mormon Church, strong opponents of same-sex marriage, and they had passed a constitutional ban. And three couples challenged the Utah law. This is their lawyer who's doing a press conference. National gay rights groups did not endorse this challenge because they figured it's going to be really, really tough to win a case in Utah. The case goes before a fairly conservative judge, and called Kitchen versus Herbert. The judge, really borrowing from Kennedy's language, says, I don't see the constitutional argument for upholding this ban, and I'm going to strike it down. And he issues his opinion on like 3 in the afternoon or something on a Friday afternoon. Now, Normally, when a court makes an important constitutional opinion, it issues what's called a stay, which is that the ruling doesn't come into effect immediately. But the judge in this case, his name was Judge Robert Shelby, doesn't issue a stay. And the Utah Attorney General's office, which was, which was having some problems, the state attorney general had been forced to resign in a corruption scandal, and his replacement forgot to ask for the stay. So the ruling came into effect immediately, which meant that as of the time the ruling came down, it was legal for gays and lesbians to marry in Utah, and not a state associated with the gay rights movement. And the result was, as marriage became legal, all of these gay and lesbian couples rushed to, in this case, the county office. This is a photograph from the following Monday in Salt Lake County, which is the largest county in Utah, because they're worried that eventually a higher court might impose a stay, which is what happened. It was like 2.5 or 3 weeks later where they imposed the stay. But in the meantime, there are 1,000 gay and lesbian couples who get married in Utah. And so that completely changes the constitutional foundation, because the question is, can a court take away these marriages after the fact? There's really no precedent for this in U.S. history. And the Shelby decision, which is a long decision, winds up getting cited by virtually every court thereafter. And what happens over the next several months is that state after state after state has their same-sex marriage ban overruled by federal courts. There's really no comparable episode in American history where court after court after court strikes down these things so quickly. The Supreme Court initially chooses not to review any of these cases, and so as a result, by late 2014, it's legal for gays and lesbians to marry in all of these states that are in green on this map, and this eventually includes Florida in early 2015. So by the time the issue ultimately will make it to the Supreme Court in Obergefell, which again we read for this week, it's only 14 states, the states of the Fifth Circuit here in the South, the 11th Circuit in the South, the 8th Circuit in the Midwest, and the 6th Circuit in the Midwest. But everywhere else, gays and lesbians can marry. And so when the Supreme Court issues its ruling in Obergefell, it's overruling a much smaller number of state laws. So that's I think the first big social issue during the Obama years. And Obama is largely supportive of these efforts, but it's mostly a legal maneuver. The second big issue is the intersection between race and crime. And in the 1990s, the Democrats were very aggressive at boosting the authority of the federal government and the authority of the federal government to aid local police forces to crack down on urban crime. You see this is the Clinton signing ceremony event for the '94 Crime Act. They have Making America Safer here, enthusiastically applauding right behind the president as the chairman of the Judiciary Committee, Joe Biden, who was the chief sponsor of the act in the Senate. It's not a pro-civil liberties measure. It's certainly not a measure that explores problems of systemic racism in the criminal justice system. And there's an element of politics to this. The Democrats had been hit hard on the issue of crime, being soft on crime in the 1980s, and the idea is that Democrats will show that they're really tough on crime. It's a reminder of, I think, the flexibility of politicians on these issues. Now, in the aftermath of the passage of the crime bill, and there's a lot of debate over whether the crime bill caused this or whether this was largely coincidental as the economy got better. My sense is more the latter than the former, but nonetheless, violent crime dramatically declines. The popular pressure on politicians to be tough on crime decreases, and one effect of the '94 crime bill is to significantly skew what was already skewed in the American criminal justice system, but it ups the effect of this. The percentage or a disproportionate percentage of African Americans who are incarcerated. So I have a couple of charts here. You can sort of look at the figures in different ways. So the first is a comparison between the percentage of the overall population and the percentage of the incarcerated population. So you can see it's pretty close with others, and with Hispanics slightly higher percentage, but not by a huge margin. With whites significantly below. Part of this is a demographic issue where whites are disproportionately older, and you don't have lots of violent crime committed by 80-year-olds. But the percentage of Black Americans, the gap between their percentage of the overall population and the percentage of the incarcerated population, it's, the figure speaks for itself. And similarly, with regards to this chart looks at the number of people per every 100,000. You see, whites, Hispanics significantly higher, and blacks much higher than this. And so there's increased attention to the intersection between race and the criminal justice system during the Obama years. Obama himself does a little here. I mean, the Justice Department occasionally is pressing police, but this is largely a grassroots movement that is focused on a couple of events. The first is the killing of a Black teenager named Trayvon Martin in Florida. The man who shoots him, this guy named George Zimmerman, is ultimately acquitted. Zimmerman said that he feared being attacked. The Martin's family says that this was an unjust killing. The verdict is what it is. And the second is a police killing in Ferguson, Missouri, where an African American named Michael Brown is killed by a police officer. And it's initially reported, a later Justice Department investigation casts significant doubt on this, that Brown was in the process of surrendering, that he had put up his hands, that he said had urged the officer not to shoot, and the officer had shot him anyway. And the aftermath of this, the Black Lives Matter movement, which was around before then, but becomes dramatically more important. And there are protests that spread into professional sports. You see people like LeBron James in the NBA or Colin Kaepernick in the NFL who stress this issue. And Obama talks about dealing with the problems associated with race in the criminal justice system, but the amount of movement here is not it's not a ton of movement. There is, however, a significant movement in New York where a federal court, first district court and then an appellate court, strikes down a New York law called stop and frisk, which had given huge authority to police to stop and search people that they considered suspect on the streets, and the data showed that if you were African American, especially if you were a male African American, you had a much greater chance of being stopped in these warrantless searches. So this issue, which I think has emerged as a key constitutional issue over the last 5 years, is percolating and becoming stronger that during the Obama years. But again, it's really mostly grassroots in this court decision rather than anything from the political branches. So that is it for our snippets for this week.